Good afternoon, everybody. Welcome to America's Great AI Debate. I am your host, Chuck Wooler. You know, I'm Martin Tully with Redgrave LLP. Glad to be here. This is the Chicago edition of the Great AI Debate. We have scoured the entire country to come up with the best topics and the best people to bring you the cutting edge issues in AI development. They couldn't make it, so today we have these four people. All kidding aside, we will be following the rules of the national presidential debate. So it's 90 minutes each person. No, just kidding. But this event is sponsored by the ChatGPT Sanctions Defense Fund, and we really appreciate their contributions to our organization and to advancing education in our field. So without further ado, we are going to do a countdown here. First, we have one epic moderator. That's me. Number two teams of debaters. You will see there's Team A and there is Team B. We have 3 burning questions, so 3 rounds for this debate, 4 sharp legal minds, and most importantly, 5:30 happy hour. So just to kind of get things rolling a little bit, we would like to get an idea of what you think about some things. So we're going to have an opening poll. Did you actually think that you were going to get here along without participating? You think again. So not only is this on blazing pink background,
you're welcome.
But you're welcome. Okay, thank you. This is a question for all of you. So you're going to read this a little bit. I'm going to stall here and talk about black and white cookies for a second while you read this. But the question is, should lawyers be permitted to use generative AI to draft discovery responses using client documents without disclosing to the other side that Gen AI was used, so long as a lawyer, or lawyers, reviews and signs the final work product? That's the question for you, my dear audience. So, by show of hands, how many agree with A, yes, disclosure is not needed if a lawyer supervises, verifies, and takes responsibility for the outcome? Show of hands. All right. We got a lot of Sedona. What's that?
What is Gen AI doing with the documents?
It generated the.
Yeah, like what's basically the documents for client's documents because it's using
to create the discovery responses. That's what it's
just
doing.
the response. It's not using it for anything else.
Not for the purposes of this question. And in the time that we have allowed today. So all right. So we have a lot of Sedona Conference Principle 6 users here. Question choice B, yes, but only if Gen AI is used solely for formatting organization and not any substantive drafting. Anyone picking that choice? Oh, we've got a good crowd here. Okay, C, well, you know, the typical lawyer answer, it depends. Disclose only when Gen AI materially influences strategy, arguments, or factual assertions. Anyone for that one? All right, we've got some takers, great. Last but not least, absolutely freaking not. Gen AI use in discovery and litigation drafting should be disclosed to the court and opposing counsel in all circumstances. All right, we got some takers. All right, well, keep that in mind, because part of what these fine young gentlemen are going to do is to see if anything changes between now and later. We'll come back to those questions. But, as I mentioned, we have 4 brilliant minds here and 2 teams of debaters. So we're going to very quickly do intros, no more than 30 seconds. I know none of you even need that long. So starting with Chris, why don't you quickly introduce yourself? Who are you?
I'm Chris Bojar. I'm the director of e-discovery and litigation support at Berg Farazano. So that's less than 30 seconds.
Excellent. More time for debating.
Hello. I'm Jamie Raba. I am a partner here at Seyfarth Shaw, and my practice is in data law. And I sort of have a presence both in the Chicago office and San Francisco.
All right, thanks for taking Chris's time.
My name is Mike Showalter. I'm a partner at Aaron Fox Schiff. I'm a litigation attorney whose practice focuses on energy, the environment, and civil rights. And I'm based here in Chicago and in New York.
And I'm John Gruen. So I'm a senior compliance solutions engineer, so sales guy for the Purview suite. So all e-discovery, data security, all of that kind of stuff, covering healthcare payer providers.
Thank you, gentlemen. And in case anyone forgot, my name is Martin Tully. I'm with the Chicago office of Redgrave LLP, where we focus on everything at the intersection of law, technology, and innovation. All right, way less than 30 seconds. So we are dealing with lawyers in the room here, so we've got to, of course, talk about the obligatory disclaimers. This is not legal advice. If you rely upon anything we say, you're foolish. Assume everything's a hallucination. None of our opinions represent our organization, our respective organizations. In fact, they may not even represent us. Some of us may or may not be playing characters throughout the balance of today's debate. Please do not attempt this at home. These are professional drivers on a closed course. Past performance is not indicative of future results. All image rights and credits go directly to the rightful owners. No copyright infringement in attendance. Please enjoy. All right. Round one. And the rules are, as Kat explained, 90 seconds each person. What we're going to do is we're going to start with one person on Team A, and then go back to the other side on Team B, back to Team A, back to Team B. So got that? All right, great. So the first question is, and our first respondent is going to be Jamie with 90 seconds. Should Gen AI be allowed to make substantive judgments in e-discovery and case strategy, relevance, privilege calls, issue spotting, et cetera, or must it be limited to clerical and organizational tasks? So this has to do with the permissible scope of delegation from humans to machines. Jamie.
To argue that only clerical things are acceptable is to sort of make a false dichotomy. Really, the real dichotomy should be supervised versus unsupervised decision making. It's sort of like saying, don't use associates because they're not perfect. No, you just shouldn't let your first year associate like turn everything in without you looking at it. Such a rule sort of flies in the face of the explosion of data, because unless we're going to also explode the attorney population, which, spoiler alert, we're not, it's only with this technology that we can actually survive. Also, it would be inequitable. As has been mentioned, plaintiffs' counsel stands to benefit because they have fewer resources and are less likely to be able to throw an army at this data. So the final word doesn't equal substantive decision. Banning substantive use also widens the gap between technical and non-technical users. It fetishizes manual labor, and hallucinations, while real, are simply a validation problem.
All right, very good. That was the opening round from Team Let the Algorithms Roll. Now we're going to hear from Humans in the Loop. As soon as the microphone comes down.
Oh, I thought we had a separate
No, we
microphone
do.
for that team.
Michael.
The human in the loop argument is basically garbage. When you ask what it really means in practice, is you're taking a person who is overworked and under-resourced and having them validate a ton of work that they can't do. You don't know. You don't know what the inputs are. Go to ChatGPT, go to Harvard, go to anything. Do a biography of yourself right now, and you'll find things that you don't know. So let's go the other way. There are people now in the academic literature talking about how AI machines could be better judges than, in fact, people. The case has been made that judges are so ineffective at applying originalist thought that you need computers to do it. That doesn't work for me. Originalism under the Constitution doesn't make any sense to me because it counts some people as less than other people, and what you end up doing is pickling the law in a time that's ineffective and talking about it as progress, and that doesn't make any sense to me. So let's go on AI to more broadly. So you take AI, you have it assemble a bunch of things, you're looking at 1 million documents. How do you look at it? How do you validate it? How do you figure out what to do? The federal rules require litigation to be just, speedy, and inexpensive. And it's surely not going to be just if you're allowing AI to make privilege calls for you when not a human being has seen those documents or other categories of documents. This is not TAR, in which we have validation protocols that folks worked on.
The buzzer actually works, huh? So I appreciate you bringing up TAR, just because I think we're just recycling the sort of TAR discussion, but now for generative AI, and the speed with which generative AI is being adopted at firms and companies is so much faster than the speed with which TAR got adopted. And so the key here is let's not let perfect be the enemy of good. There's our firm's assistant general counsel loves to say that, mostly because we need to move in the correct direction, right? So we have these technologies available to us. So if we don't avail ourselves of those technologies, we're essentially tying one arm behind our back. And so as a result, I think we need to start pressure testing them. And again, I think it's maybe slightly unfair to say that humans aren't in the loop at all on this. Obviously, we're going to back it with some human use, but we do need to avail ourselves of those technologies because, like Jamie said, we just don't have the humans to actually plow through all of this. So I'll leave it at that.
All right, well done. Final word from humans in the loop on round one.
Right. So the big thing about humans in the loop is, so if as a vendor, Microsoft is really great. We know about patent law. We know about how to sue you if your licenses you're out of compliance with that. But you're really trying to, do you really trust me to do all of your legal stuff for you? That's what it is. Essentially, if you don't have a human in the loop, then you're trusting the nerds, which, yes, we trust nerds on a lot of things, but, we are not infallible, and we've gotten everything from Copilot is fantastic to Copilot is the Clippinator, Clippy in the Terminator suit. And that's the kind of thing that we end up with of, when we're dealing with something that, hey, where do I go to dinner tonight? That's one thing. But if someone's life is on the line, or they're going to be in, criminal contempt or something like that, that's not really something that we want to leave up to the people like me. I'm a nice guy, but at the same time, I am not a lawyer, and the people who are developing this, we're not lawyers either. So that really is a thing of, how much do you really trust us? Not that we can't be trusted, but at the same time, we're not the ones that are making this decision. And if it goes wrong, there's millions of these transactions that are happening. So to us, one transaction is but if to you, it's a really big deal. And for that, you really need to have a human in the loop. And it's why we named our system Copilot. The co in that is very much important. It's one of the few things that we got right on the naming scheme. Microsoft did a lot of weird namings, but Copilot in that, the Copilot is very good. We're not the pilot. We are the ones that are helping the pilot do the job.
All right, well done, debaters. Well done on round one of the debate. I can just see the audience literally on the edges of their seats. Literally on the edge of their seats. Maybe because the building's swaying slightly at this height and the width, but I don't know. Yes, that does happen. All right, now we're going to go to round two. Round two, and we're going to switch things up a little bit this time. I'm going to call on Chris first for Team Privileged and Protected, and John for Team Produced and Published. So the question, dear audience and debaters, this time in round two, is can generative AI be used safely with client documents and discovery, including things such as personally identifiable information, trade secrets, privileged communications, oh my, or does it create unacceptable leakage and waiver exposure risks? We'll start as advertised with Chris. Privileged and protected.
So yes, right. And as long as we don't move the goalposts, because I think the counter argument to this is that people are using systems that are not, from corporate, or they're not maintained, and we're not logging that. So as long as we're not using kind of the arguments of working outside the bounds of the technologies that we have, I think these are protected. And frankly, Claude's the example that we've talked about a lot here today. That caught on like wildfire at our firm. But we obviously spent time doing sort of security checks, making sure we have our own private instance, and making sure that whatever we're doing is actually being logged and taken care of. So as long as you're following the proper protocols, I forget who said it, since we've had so many people, but the process, if you're following the process correctly, then we're comfortable with using these technologies. And if we find out that there's something wrong in the process, obviously we're going to fix that as soon as we possibly can. But using your own corporate environment in its own confined space, I think is safe. And as a result, it stops people from working outside the bounds of where they would, where I think there could be problems. And frankly, data might show up at some point that shows you that you've done that outside the bounds.
Thank you very much, Chris. John, with the Team Produced and Published. Is it Katie bar the door?
No, I don't think the door is totally barred to it, but I also, looking at the just general governance out there, the fact that I have a job is a statement that the governance is not where it's supposed to be. We've created sensitivity labels, we've created DLP systems, we created all these things, and yet people still do dumb stuff. People talk about the, Project Mythos and Project Cloudwing, which is finding the little tiny thing. But if you're a hacker, I don't have to go that far. Screw it. People are doing dumb stuff every freaking day. They don't have two-factor authentication. So it's not that we couldn't do it because, the technology doesn't exist, but the implementations, they're just not there yet. And the problem with it, I think, is, is there a spot where it could get to the point where it's good enough? Yes, but I think, again, going back to the argument of someone's life is at stake 10 years or, more, they're having a felony, those kind of things, do I really trust it that much? And, again, IT nerds, we're fantastic, but have we rolled everything out to everywhere in enough? The vast majority of my customers, even my really, really good ones, there's still hesitancy over automatically labeling stuff at birth. There's hesitancy over, well, DLP is kind of a thing that you want to do. Or, retention. We have people that retain forever. Do I really want to do this if it's AI and I'm using stuff that I've retained for forever? There's modern law, but there's also things that, hey, this was what I did for the last 10 years, and that's the preponderance of the evidence standard. Hey, let's end up doing that.
All right, thank you very much, John. We'll go back to Team Privileged and Protected. Jamie.
Hello, hello. Well, ladies and gentlemen, do you remember when using Gmail was supposed to waive privilege because, the ads were reading your emails? That didn't really go anywhere. But you probably remember that when technologies are new, people are more worried about them than they possibly need to be. But you know who you should be really worried about? Humans. Humans aren't perfect. We send all this data to translators, examiners, forensic specialists, e-discovery folks, and we're perfectly happy doing that. And I think as long as you have, a contract, you can protect PII, privileged data, confidential information, as long as it's licensed. And remember, privilege requires reasonable precautions. Literally, the perfect is not the enemy of the good, even in our ethical standards.
All right, nicely said. And we'll get the cat avatar to sign that protective order tomorrow.
Trust us, say the corporate shills to my right. If
Damn.
horses had 3 legs, we might call them triangles.
I don't have a problem with that.
We're talking about data, and we're talking about the use of generative AI in a system in which misinformation and invalidation are readily apparent to anybody around us. Let's look at the first government application of AI, Doge. How'd that work for y'all? So now you want me to risk my law license, where I am paid to bury people's bodies by giving it to some black box computer, with this being my guarantor? I don't think that's wise for my clients, and I don't think that's wise for me. Trust us is something that is every government, every company that's done a bad thing in history has said, trust us, look at us. We wear nice blue blazers and have fantastic voices. But these are not things that we need
I only
to
have one of the 2 of those. Okay, I don't have a nice voice.
And as a vendor, it's very much the trust and verify, even with us. So we get beat up on this all the time. It's one of the fun things about being a vendor.
All right, now we're cooking with gas. Round 3, final round. This round, we've got Team Full Disclosure and Team NOYB, or as they tried to convince me, NOYFB, but I wouldn't put this in because it's a family show. Round 3 is transparency and disclosure. So the question for our debaters is, should parties be required to disclose Gen I use in discovery and litigation drafting, whether it's RFPs, requests for admission, responses, it's interrogatories, et cetera, privilege logs, and briefs filed with the court? And again, we're going to start with Team Full Disclosure. Yeah, turn it over. Jamie, 90 seconds.
Oh, yeah. Yeah, we should disclose always, but not for the reason you think. Because humans are part of the problem. You see, if you're not using Gen AI, there's a high likelihood that your responses and your pleadings are based on incomplete understanding of the data. Because again, The data explosion is hard to solve by just throwing humans at it. It's a sign of quality and exhaustiveness. Also, it promotes trust and reinforces professional accountability and the expectation of competence.
Mike, tell us why it's none of his business.
One simple question. If you're litigating a case against someone else and you're getting ready for trial, would you want to know if they use generative AI to formulate their discovery responses? And the answer has to be yes. So how do we deal with data? We deal with data by working through the processes which are envisioned already in federal and state rules. We have proportionality, we have disclosures, we have these things. We don't need a magic box and a faceless robot to help us pull this information together, because there's negotiations, candid negotiations, open negotiations with opposing counsel, so that we can get to the best approximation of truth in a way that we have done it in the Anglo-American tradition for like 500 years.
Chris, back to team full disclosure.
So earlier, Kristen talked about trust, and I feel like that response doesn't build a ton of trust when you want to disclose absolutely nothing about what you've done. I mean, I think there's a give and take on this, right? Everything that you do, you're not going to spell out down to the last, thing. But we also know that a shoe company recently became a Gen AI company. You could be using Allbirds AI, and we don't know that. So I'm not saying we have to do a full security test on everything that you guys do and break everything down, but I think a little bit of disclosure helps us at least get some trust so that we're on the same page, or at least close to the same page. And then once we do that, then we can build forward and make sure that the systems we're using or the processes that we're following, we're all comfortable with.
You're quite fashionable men, so I'm sure you're using Allbirds.
And this would be so much less funny if we didn't have our internal demo client is named Zava, which actually internally was a shoe company when they first posted it to us. The real question for us, though, is, if you're concerned about generative AI, well, why not at Word? Why not Excel? Does it matter if it was on a Windows machine, on a Linux machine, on a Mac machine? Does it matter if I did it from my iPhone? It doesn't really matter, as long as I eventually looked over it and then said, hey, here's how it's done. Because if something's going to go wrong, you're not going to sue the computer. You're not going to sue us as Microsoft. You're going to sue, hey, no, that idiot over there is the one that made this preposterous statement, and they're the one that carry the liability for it. It doesn't really matter how it gets done. Now, it does potentially factor into things like how quickly can you get it done, and some things are just going to be assumed to be generative AI, but if we were negligent and we'd used something, hey, I got out Excel and I figured out all these things that it turns into dates, and it wasn't actually dates, who cares about that? What matters is that, when it push comes to shove, that it got done and it's to some level of standard. Now, my standard is not going to be the same as anybody else's standard, but that's what the judge is there for, is to help figure that out. It doesn't matter that I did. If it's really questions of my competence, it doesn't matter what the tool is. It's really a question of that person's competence, not what tool they were using, unless they were completely out there and used like Windows 95 or Windows 3 to do their stuff now.
All right, thank you very much. Let's give a round of applause for our master debaters. Now we're going to go back to you, because I know you all have minds like steel traps and you remember every single thing that they said. We're going to go back to round one. Refresh your recollection as to what the question is. By show of hands, which team do you think had the more persuasive argument? Let the algorithms roll? Okay, or humans in the loop? All right, look at that. Kind of down the middle there. Round two, privilege, confidentiality, and waiver risk. Refresh your recollection of the question. Who do you think had the more convincing position? Privileged and protected, by show of hands? All right, we've got a lot of shy people out there too. Or, show of hands, produced and published. Oh, I think produced and published got that one. Interesting. All right, then round three, transparency and disclosure. No controversy here whatsoever. Refresh your recollection as to the nature of the question. By show of hands, who think that full disclosure had the better argument? All right, okay, some. Who thinks that none of your business had the better argument? All right, kind of split on that one. So I would say we have 1 win and 2 draws, what I would say. So let's move on a little bit here and try to recap some things. I did my best during that blizzard of brilliant exchange of words to try to capture some of the highlights. First of all, I don't know what came after fetishization, but that's all I wrote down. I don't know what that says about me.
Fetishizes manual labor.
All right, that one, I just almost wanted to vote for it just because of that turn of the phrase. Judges just should be replaced by technology, and the bench should go away. That was an interesting point. But there's something there actually, because one thing that doesn't come up, I think, often enough in this is where I get to give my opinion, by the way. Well, this is one thing I don't think comes up enough in the AI debate is something called access to justice. So there's some places where AI can actually provide that judicial adjudication in a way that is more accessible and far less costly for those who otherwise would be kept out of that role. Now, do we have a lot of work to do before we figure out how that actually will work properly? Because if my life is on the line, or even my my home or my wealth, sometimes maybe I want perfect and not just good. But at some point in time, is the good in that situation better than the perfect in terms of giving people access to some justice that they otherwise wouldn't have, or bringing down the costs of the legal system overall? Okay, end of social speech. Actually woven the next thing in there. Great comment about Copilot for a reason, because this is and I know Kat loves this line, is artificial intelligence more like the T3 and Skynet, where it's going to wipe us all out, or is it more like Jarvis and Tony Stark, where we want to have a tool that is going to augment our ability as a human? And I think that's what you were going for with Copilot. And I certainly want to have a good Copilot in my car when it's an autonomous vehicle, because that's another example where I might want to wait for perfect before I drive good. All right, Russell, round 3, is our usage privileged? So a lot of good points there. Yes, it's protected. The fact that I still have a job means it's not perfect. That was a good one. Every time new technology shows up, everybody freaks out and says we're going to waive our privilege. Whether you go back to the internet, you go back to big data, or you go back to the metaverse, or just go on and on and on, every time something has become the it girl in terms of technology, we're all losing our privilege. And there's a panic. So it is a pendulum that I think is not well supported. And the other thing that gets lost, and I'm glad to see some courts are looking at it this way, is the same rules of privilege basically apply. It might be a shiny new bottle, but the rules are the same. And oversharing, whether you're using Gen AI or you're using a tin can with a wax string, can still waive privilege. The same rules should apply, and I think that the more judges and regulators and lawyers go back to the basics, I think the better that we will be able to incentivize more use of these things without unnecessary fears. Trust us, that's a good one. What was the comment before during the right before this session? We're all trusting everybody when they say in their terms of service. No, we're not sharing that with anybody. We're not training any system on that. There's a level of trust throughout all of this. Is it a reasonable level of trust? Interesting. We'll see. Round 3 was is disclosure required? Now this is one of those things where some would call these fighting words, because some of us have Sedona Principle 6 tattooed on our forearm, like me. But there are many situations where it would be strategically advantageous in a piece of litigation or a dispute to have some disclosure, because it can avoid headaches and costs and difficulties down the road. And if ultimately you're trying to achieve the goals of Federal Civil Procedure number 1, a little bit of maybe not required disclosure and negotiation and cooperation might get you a long way. So even though I don't have to, maybe strategically there might be a reason to do it, depending on the judge, the other side, the stakes in the case, so on and so forth. It all kind of depends on what the circumstances are. The interesting thing is that when it comes to disclosure, what is it and to what extent are you disclosing, and how deeply do you have to go down that rabbit hole? Because that can then have the opposite effect. And frankly, I think that's why we're seeing, and tell me if you think otherwise, in the real world, a lot of people are just avoiding this topic altogether. in 26F conferences, Rule 16B conferences, in ESI protocols, because they don't want to go down this rabbit hole of having to argue about these things, precisely because it'll take time and money. So we tend to have a little bit right now of a don't ask, don't tell, because we just want to kind of get to the issue. One thing I have to say here, and I often get either applauded or criticized, so we'll see which one you like, is the point was made, is it about the outcome or is it about the process? Do we really care about the process if the outcome achieves the goals of the rules and Rule 26G? Some would say absolutely, process is very important, but isn't it really the outcome that we're talking about? Well, how do I gauge the outcome if I don't know the process? These are all good questions. But in some respects, if I were to print out all my documents in a case, throw them down a flight of stairs, and only produce the ones that landed on the first 10 steps, but those happen to be all the responsive documents, who cares that I literally threw a box of documents down a flight of stairs? Extreme example, but I think it focuses attention on what is the outcome, and is the outcome consistent with the demands of justice, as opposed to details about the process. So
The
that
Sedona Principle 6 says that's acceptable, right?
it
Because
does.
you're in the best position to choose that technological stair.
That's right. And if I have litigated 437 slip and fall cases and I threw documents down the steps, and in every case nobody complained, then I have a good case that my process is fine. All right, so one of the things we want to do now, because I don't let them rebut me, one of the things we want to do now is go back to you, the audience. So remember our opening poll. The opening poll was, should lawyers be permitted to use Gen AI to draft discovery responses using client documents without disclosing to the other side that Gen AI was used, so long as the lawyer reviews and signs the final work product? I can even actually go back to that, because I'm sure somebody's saying, Martin, why don't you show me the darn slide so I can read it again? Rather than going through this and taking another show of hands, what I want to just ask, and that's perfectly fine, because any responsible adult, when given new information and new positions, will occasionally change their mind. Based on your response earlier, so it's an honor system, how many of you have changed your mind with respect to your original answer on this question? Okay, so congratulations, you moved the needle a little bit through your positions and your discussion. So now, we are going to give these gentlemen who had to sit here and listen to me blather on an opportunity to give some closing statements. And we're going to keep this to 1 minute each. So it's 2 minutes for team A. Actually, you know what? Take 3 minutes, because I went on long enough. I'm going to give you my time. So each of you get 2 minutes. I think that's acceptable. All right. Our producer in the booth is not yelling at me, so that's fine. Why don't we start with Chris? 2 minutes.
And you want us on anything we want to talk about here, or something?
I'm going to let you be yourself and say whatever you want.
Okay. So let's talk about sports. No. It was a point I was going to bring up in the full disclosure. Something that came up in meetings internally was, if you're not going to talk about Gen AI use, and you're not updating your ESI protocols, you don't necessarily know what opposing counsel is going to do with your documents. So we've actually started updating that, and maybe people are ahead of us on this, to make sure that it's explicitly stated you can't use our clients' documents in open systems, right? And part of it comes down to, we should trust each other, but I think you need to make it explicit. Now, the only part I worry about is you see these old document requests, and they reference like microfiche, and you know what I mean? They reference systems that are like no longer used. But I do think in the Gen AI world, putting in caveats to that and making sure that the documents don't go into other places is super important.
Thank you.
One thing that I think is really important is that when you're sort of coming up with a strategy to use Gen AI, is to do it in bite-sized pieces. I think one of our problems is sometimes Gen AI, the input is too great and the output's too great, so it doesn't have enough interaction with the user. And so I think no matter what you're working on, I think it's best to give it a case and then say, using this case, I'd like to make the following arguments. And then, that way you're interacting with the case, and then you're building your brief or your discovery response a paragraph at a time. And so to me, you're going to just have the most powerful argument when you have ownership over the input and the output.
I agree with that. The other tough thing about Gen AI in the context of courts, and I really appreciated the dialogue before about trust. I mean, a lot of us spend our careers kind of ramboing around the country into all different circumstances, and you're going to find judges and opposing counsel who have vastly different experience with Gen AI and with TAR and with anything else. And as much as you might want to disclose things in those circumstances, you're not going to have a productive dialogue, and things will break down, and you're going to have to fight. So, you know, I'm all kind of grew up as a Sedona conference person too, and I'm all generally theoretically for openness and disclosure, but my gosh, is that tough in practice?
So for me, I mean, the big thing for me, I think that generative AI has really done a great job for the cybersecurity industry in that everybody that, you know, they thought they had problems. In some ways, this is very similar to a problem that we had with enterprise search that happened. Enterprise search happened, and everybody was like, "Oh, it's indexed. Oh, wait, I can find everything." Oh, crap. You know, generative AI the main thing for us about generative AI is it's just lowering the bar to that discovery, to the ability to do it. But it also has a great output. The real thing that, you know, I'm looking at from a Microsoft perspective is really, has the security all kept up? And we have a lot of customers like T-Mobile, they get breached on a regular basis. You can set your watch by it at this point. And I had a customer, I won't disclose their name, but they got breached a year and a half ago. We told them, hey, here's all the things you have to do to fix. And then they came back to us about a month ago, and they got, you know, an even worse game over event. I don't know how you do that, but they did that. And that's really the thing that, you know, I think that generative AI is going to force a lot of these companies to be like, hey, you know, the attacker is smart and they are using Gen AI, so you should too as a defender. But it's also, we have to really, you know, between that and the upcoming quantum apocalypse, you know, it's going to be a very interesting set of years for us on it. But as an industry, I think that we're ready. It's just a question of, you know, how fast can we get this done and how much money are we able to actually throw at it. I suspect that it's not enough at the moment, but, you know, I think it'll come.
Thank you for those insightful perspectives. And I just had to pick up on something that Chris said about some of that out-of-date, obsolete language that you see in orders and document requests still. And I was just reminded of a standing order in a certain state, not federal court, state, which will remain nameless, where it went on to talk about the definition of documents, and somewhere way after the word writings, it included things such as jottings and marginalia. And I was wondering, how is that different from writings? And this is where you end up with a room full of lawyers, because people will actually litigate the difference between jottings and marginalia. Really want to ask for a round of applause for the debaters, because they didn't know what they were all going to say, and it was all done live. Welcome to the tightrope. Thank you very much, and now we're at time.
Awesome. Thank you guys so much. Give them another round of applause, because this is the hardest one to do.